and paints. We have Mr. Lieberman, partner, Emery, Celli, Brinckerhoff, Abady Ward, Maazel LLP, Mr. Stephen Com, partner, Combs and Greene, Anjali Pahwa, senior vice president, draft and craft, Miss Ann Wolfson, chair, small law firm committee, New York City Bar Association. This discussion will dwell into the implication of virtualization, post-pandemic ethics, professional responsibility, compliances, and the role of alternate legal service providers.
Thanks, Sagar.
Thank you.
And first of all, thank you to the CGI and SEPC for giving us the opportunity to bring forth this panel discussion and talk about the collaboration of attorneys and remote paralegals in this day and age when we are talking about collaboration between India and US. Now, when we talk about the export of legal services, the first thing which we talk about or think about is all the cross-border work which is happening, the M&As which are happening. But we don't give too much focus on the use of legal services by the US attorneys from India. So if we talk about the legal services market, the LPO market in India is of $20 billion. And the biggest part of this is coming from the United States. The United States is the biggest export destination for India. In the past couple of years, we have seen a big boom in this industry. We've seen a lot of work flowing in. A lot of changes have happened post the pandemic. So from 2020 onwards, a lot of things are happening, a lot of changes are happening. People are becoming more receptive towards outsourcing. People are getting more aware about things, because at a time when people wanted to work in a conventional way, where things wanted, everything needed to be within the office, the pandemic forced us to become absolutely remote. And that in itself, opened a door of opportunities to go beyond what they were already doing. So keeping this theme in mind, we would, let me just first introduce myself, which I missed. So I'm Anjali Pahwa, and I am the Senior Vice President for Draft and Craft. Now, as part of my job role in this company, I oversee the entire operations. I also work closely with a lot of attorneys, a lot of law firms in the United States, and I help them develop a lot of customized solutions for them and help them meet their objectives. Draft and Craft has been into this industry for over 15 years now, and we have been, at this point in time, we have our clientele in 45 plus states. We have a client base of over 300 law firms, and so that's a bit about what me and my company. I'll pass it on to Steve and Hal and Ann to introduce, and yourselves.
Okay. I'm Steve Combs. I've been a lawyer for right at 30 years. I've had a very diverse practice. I've done different things. I was a family law magistrate at one point in Florida. I was general counsel to the local court system at one point. I've done commercial litigation, family law, and now I practice almost exclusively with personal injury. I still, though, have I ran for judge and did not win, but I developed a understanding of judicial election ethics, and so there are a number of judges that come to me from time to time for a little bit of advice on that, and I taught at our local law school 12 semesters, and so I've taught Florida constitutional law, remedies. Can't even remember the other courses I taught, but anyway, so that's my background.
So first of all, I really do appreciate the invitation to speak to this group. It's an honor and a new experience for me, and I've learned a lot, especially the last session, which was great, and you're to be complimented for that session. It was very informative for me and helpful, I think, for this session as well. My background is I practiced law for many years, 50 years, which apparently gives away my age. I have a diverse background, mostly in public interest work. I've worked for the government as a lawyer regulator, and then I have spent the last 20-some years representing lawyers and law firms in legal ethics and disciplinary matters. I've been the managing partner of a national law firm with the New York office, and I'm now a partner in a smaller boutique law firm that does a lot of civil rights and civil liberties work. But we've also parenthetically had several lawyers who were born and raised in India who worked. One is back in India now, another one is in our firm. So I've become a little bit familiar with the Indian legal system, but not very much. And my purpose in this meeting is to talk more about the American ethics, both the substance and the regulatory scheme, as well as some of the difficulties with reciprocity from this end.
Thank you. I would also like to thank you for inviting me to do this. It's a great honor. And like Hal, I learned a great deal during the last session, so thank you to all of you who did that. I think it will help a lot in this discussion. Like my colleagues, I have an eclectic background. I actually started out as a software developer before and during law school, and my intention was never to work in tech again, which isn't what happened. I was a banking regulatory attorney for several years, and then during the initial internet boom, I saw who was getting hired to do what I thought was more interesting work and turned myself into a technology lawyer, which I've been doing since the mid-90s. Since 2000, I've been working cross-border, both with Indian attorneys, not so much with Indian companies. Mostly in my role, I was in-house for 16 years with companies that had significant overseas operations. In some cases, they were not U.S. companies. The parent companies were not U.S. companies. And through doing that, I've learned a lot about how to communicate, how to work effectively with distributed colleagues, operations, working remotely long before anybody called it that, doing conference calls at 5:30 in the morning because that was the time that worked for everybody else. And I'm here, I think, to talk about that experience. I'm also the chair of the New York City Bar Association Small Law Firm Committee. I'm a solo, and I've been a solo for 11 years. And that, I think, also informs this whole process of working remotely and working in collaborative teams.
Right. Thank you. And to begin, what would you say in terms of how has the role of attorneys and paralegals evolved in this time of remote working? How have things changed?
Well, I think those are two separate questions, because I think the role of paralegals has been changing regardless of this acceleration of remote work in the last 3 years. They're allowed to do more, we need them more, and many of them are not next to us. They're miles or hundreds or thousands of miles away. So I think what really has changed is that we've all had to learn how to communicate more effectively, both in writing and in speaking and on video, but we've also had to learn how to trust each other more. I think that's the basis of this kind of work, is you have to develop a trusting and openly communicative relationship. And I think that really what's happened is we were all stuck at home for 2 years or 3 years or whatever it's been, and we've had to continue doing our work with whomever we're working with.
Steve, would you want to add something to it based on your experience so far?
Well, you know, my experience has been that, at least in North Florida, the market for law firm employees has constricted for some reason due to the pandemic, and I don't really quite understand. I don't know if it's an expansion of the need for paralegals and legal assistants, or if it's people leaving the workforce. I'm not really sure, but I know that we've had a terrible time finding people with experience. So.
Right. Hal, have you had I mean, obviously, when the pandemic started, all firms went remote. What was your experience out of that?
Yeah, well, our firm has struggled with the remoteness, and certainly we haven't expanded during the pandemic. The problem really is with the younger lawyers who need to be in a much more direct relationship with the partners and the senior people, and yet this pandemic has had an effect, and we're still not fully back in the office. But our firm doesn't have an outreach program whereby we employ, as many small firms don't, people from outside the U.S. because we don't have an international practice.
Right.
But I can certainly speak to the more global look in terms of protectionism in this country when it's my turn. That's probably, I don't have much to add to what my colleagues have said.
Right. So Steve, when we talk about, using or having remote paralegals or, legal assistants or employees working for you, we obviously go through a lot of challenges. What are the challenges you've seen, and how have you overcome that?
Practical challenges? Okay, so I have been working with Draft and Craft for maybe 7 years, about that. Denise Muhammad had sent me multiple emails over the course of about a year, and advertising Draft and Craft's medical records summary service. And so I had just paid $4,000 for a nurse to do a medical record summary, and she gave me a notebook with a bunch of yellow tabs on it. And I realized I needed another system. And so I started working, engaged Draft and Craft. And then this past, about a year ago, I had an employee, a non-lawyer employee, whose entire job was to assist with procuring medical records. As a personal injury lawyer, that is probably one of the most difficult challenges we have from a logistical perspective, always having to obtain medical records and then re-obtain medical records after a span of time has gone on. My employee, who was a college graduate, was not a true paralegal, but was in charge of the fact his dad was an old client of mine. His dad said he lost his job, can you hire him? And I'm like, I don't hire children of my friends. So I said he could come work for me for 12 weeks and then he's out. And then he worked for me for 7 years. So, but after he left, I looked at replacing him, and it just was not going to be cost effective for what the market had to offer. So I reached out to Denise and Anjali and obtained a full-time equivalent paralegal who is actually a barred attorney in New Delhi. Which nobody told me that for a while. I had to discover that as I was having him do some of the most menial tasks, including getting medical records, which that's his primary job. But he has a great deal of competence as a thinking lawyer. Kind of reminds me of Paper Chase. So anyhow, so some of the challenges, first of all, language can be a barrier. I've done a couple of evaluations for my paralegal, and but the other thing is the holiday schedule in India. We have a small family law firm. My wife is a divorce lawyer, and as I said, I primarily do personal injury at this point. And then we have 3 lawyers that work for us. And one of the lawyers, my lawyer who helps with personal injury, is actually one of my son's best friends from high school. And I've known him forever. And in fact, I got him written up at a grocery store that he was employed at. And then I told him to come work for me as a runner. And then he eventually became a lawyer for me after some amount of time. So we're not really very difficult employers to work for. And so when we were contracting with Drafting Craft for a paralegal, I wanted to honor my Indian full-time equivalent employee. And so the holidays can sometimes be an issue. So, but sometimes explaining what I want done can be an issue that is really resolved by a conversation after a first
The
attempt.
clear communication.
Yes.
Having the clear
Yes.
guidelines which are there. in
Right,
place.
and I think that is the same with anybody who'd be working remotely.
Right.
And my wife and I, my wife's 60, I'm in my late 50s. We don't plan on practicing maybe another 10 years. And so we, for our own personal satisfaction, still haven't gone back to our 5,000 square foot office, which we're still paying for, and we have a couple of staff people there, but our lawyers haven't gone back yet. So the difficulty with an outsourced paralegal is really no different than I would have with an outsourced paralegal if they were across town.
Right.
So,
And would you want to add something to that? Because you've been working virtually for the longest time, right? So anything you would want to add on this point? How can we make things better? What are the challenges you have gone through and the possible solutions to make this relationship when you're working virtually better and more fruitful?
So what I found, the first time I really needed to worry about this at all consistently was in 2000. I began working for a Swedish fintech company. The lawyers were mostly in Stockholm. There were some in Halden, Norway, and some in London. And then there was me in New York. And of course, I was 6 hours behind everybody. We eventually added people in other cities, including Helsinki. So what did that mean? It meant that, and we used the same agreements around the world. So deals we did in Korea were all done under New York New York law or the law of Britain and Wales, or England and Wales rather, which meant that we all had to be very familiar with the language in those agreements. And the idea was that we would be able to back each other up, because essentially what happened was the Nordics shut down in July, and I had to do all the deals around the world, always under New York law. So having me in New York was kind of novel, and I needed to get up to speed very quickly. So what I did was I insisted on a weekly phone call. We didn't have video back then, but every Friday morning at 9:30, my time, 3:30, 2:30 or 3:30 their time, we would all get on the phone and we would talk about what we'd done that week, what issues we'd run into if we had not already worked them out by email, with a group email, what we were expecting to happen the next week, which days we'd be out of the office, because the remote situation, the working from home situation was complicated because of slow DSL speeds and things like that. But I think and they were very surprised that I was doing this, and I said, look, I need to know what you're doing so I don't make stupid, avoidable mistakes in the agreements I negotiate. I need to know where your thoughts are on these different points and what you've encountered. And we did that very effectively for 6 years. There were periods when I could not travel. There was I was pregnant, and my doctor wouldn't let me travel for a long time. Is this working? It is working.
Yeah.
Okay. And then, of course, there was 9/11. I was actually 33 weeks pregnant on 9/11, which is another story. I worked across the street from the Trade Center. But I couldn't travel for a long time. So having these meetings, and then we got sued for patent infringement. So I actually couldn't leave the office for a week, as was necessary for these kinds of meetings. So the fact that we had established very effective electronic communications meant that we could work seamlessly together, including with the paralegals who were in the home office. When I began working with colleagues in India later at other jobs, what I found was the time difference was much more complicated. But new forms of electronic communication helped us get past those things, but it was really about establishing regular, consistent, clear communication habits.
Right. Pretty much, I mean, I would agree with it 100%. Once you have a clear understanding as to what is required, a clear communication line which is there, which is opened up. And I think with the technology, the advancements which we have made in the last couple of years, it has eased out this problem. You know, it's not so bad as how it may have been back in the days. In the last 3 years itself, I mean, no one would have thought we would use Zoom so much, you know. We're using it left, right, and center now. So communication lines, yes, but I would just like to add a point over here that when you are clear about what you want the other person to do, you know, and if you have a clear set of guidelines, a clear set of procedure already laid out, the next person is easily going to be able to adapt to it. But if things are complicated on one side, it is definitely going to remain complicated on the other side as well. So clearing everybody's houses, creating a set of guidelines does help out in making this collaboration a little more easier and a little more productive and efficient. What would you say, Steve, on that? Do you think I'm right?
Yes, I do. I think where it becomes difficult is when you have what is an occasional assignment for, say, your paralegal that he or she's never done, and you're trying to explain it.
Yeah.
You know, and so it's a kind of filling the gap of my paralegal. His primary job is to obtain medical records and to document where we are in every case. So I could, we have a shared drive. So I could go onto my shared drive, pull up the Excel spreadsheet. I know exactly what's been done.
Right.
Okay. But that's not a full-time job, you know? And so I'm constantly trying to think, well, what can I delegate that I don't need to do, or I don't need to have my associate do,
Right.
or I don't need to have my secretary do.
Right.
And then that is the only time I have issues in communicating, because it's something different, you know? And it doesn't help that I still use WordPerfect for most things. So.
I would agree on that.
But it's a much better word processing program, and your documents will look so much better
Maybe
using WordPerfect.
maybe that's debatable. You know, that's a whole different topic.
Yeah, WordPerfect X3,
God.
WordPerfect 23. I'm going on 36 years of WordPerfect.
I didn't know it still existed.
35 years of WordPerfect.
Wow.
So, but I still use Word if I have to, you know. But I will say the development, though, over the last 3 or 4 years really helps the collaborative process. I have a of-counsel partner who basically was my best friend from high school and college, who does personal injury. He's done it that's all he's done for 30 years. And so he works some of my cases with me. We worked together. And so we had this big products liability case recently. And so we could be in different places. I could be in the middle of a deposition live. He could be watching by Zoom. My associate could be in another room with an expert witness watching the same deposition. And we're all communicating in real time on Google Docs as we're sitting there. I'm sitting there doing a deposition.
Right.
You forgot to ask this. You know, with my paralegal in India, we often will have meetings of the entire office and my team, and he'll be there as we do file reviews and such things, and I find that very helpful.
So when the entire concept of outsourcing started, we always thought about e-discovery, we talked about IP, we didn't go into the other services, but there is a large chunk of services, a very variety of services which are still getting outsourced to India. Steve, you are already part of, the other part where, things are beyond the e-discovery, where it's, of course, it is prevalent. A lot of large law firms are, working just on e-discovery when it comes to outsourcing. But there is a need of other services as well. In fact, we were just talking about it, Steve. I talked about the fact that I was reading these statistics from the US Labor Department, which said that between 2020 and 2030, there is going to be a huge demand rise for legal assistants and paralegals. Now, that itself shows that there is a lot of scope in terms of outsourcing such services. Steve wanted to talk about the fact, he did mention that there is a demand and supply issue, that there's a lot of demand for it, but there is a lot of supply issues over here. So that, of course, can be met by contracting with ALSPs. How do you think that's going to move forward? Or what are the kind of services you feel are the best treated or best handled from a remote location? Feel free to jump in, anybody.
Well, I think there's going to be an evolution on both sides of the Pacific, because I think there will be an increase in the need, but given cybersecurity issues, given confidentiality issues, there are certain things that even my firm has been hesitant to offshore, specifically family law. And the reasons we've been hesitant with family law is because we have our clients' credit card numbers, okay? We have our clients' bank account numbers, and there is a level of due diligence that is difficult to achieve when you're sharing that type of sensitive information with somebody outside the firm. And so I don't know where that solution is. I know, and we'll talk about it in a little bit, the ethical issues of outsourcing. But that is a key practical issue that at some point, everybody has to evolve to be able to accommodate that.
Right. Hal, would you want to pitch in on this?
Yeah, let me say something more global, and just kind of following up on the last session. It seems as though India is making huge strides economically, as well as this notion of opening up for American law firms and lawyers. But the key concept seems to be, at least in the minds of the Indian bar, the BCI, reciprocity. And I think the last panelist discussed, I think one of the last headlines was on flexibility. And the one problem that I see is that from our perspective as American lawyers, and then from the bar perspective, we don't have the flexibility that I think is required to have meaningful reciprocity. This is not good news, but it is the simple truth. And it should be said that this is a very protectionist bar, and it has been for a long time, and it's going to be hard to break that notion. I think we've made some strides, but let me just talk a little bit about the history of bar regulation and the ethics rules. We, for the first 120 years of our existence as a democracy, as a country, we didn't have any rules. I mean, it was pretty much left up to the local bars, and in fact, we didn't even have law school requirements. I mean, one of our most famous lawyers, Abe Lincoln, never went to law school. He studied with another lawyer. And only in 1908 did we promulgate the first rules of conduct for lawyers. It was called the Canons of Ethics. And by the way, most lawyers didn't know how to spell the word canon. They thought it was a gun.
It's not?
No, it's not. That's spelled with two N's. But that's Canons of Ethics. Very similar to what you gave me, the rules of the Bar Council of India relating to lawyers is very similar to a lot of the language in the Canons of Ethics. And that lasted until about 1970. So almost the first two-thirds of the 20th century, we had the canons of ethics, which was very hortatory and sort of flowery language about lawyers being ministers of justice and being honest and so forth, and forbidding advertising and so forth. But in 1970, the ABA, the American Bar Association, adopted what was called the Code of Professional Responsibility, which was a very big change over the canons. And it was much more specific and did away with some of the flowery language and was much more specific in terms of the details of regulation. And they thought that that was going to be the rules that were going to govern us for the next century, and it lasted all of 15 years. And then in the 1980s, as a result of Watergate and some other things, we then the American Bar threw out the code and promulgated what's called the Rules of Professional Conduct, which then had to be adopted state by state. And just as an example, New York only adopted the Rules of Professional Conduct in, I think, 2012 or 2010. Took a long time.
Very long time.
But the thing about the United States is that every state has a separate, most of them based on the ABA model rules of professional conduct, but every state has separate rules. And so for practice from one state to another is complicated, because if you're going to go into that state, apart from the regulatory stuff, which I'll get to in a minute, you have to be familiar with the actual the ethics rules, which are quasi-criminal in the sense that they, if you violate them, you're in trouble with the bar, just as if you violate a criminal law, you're in trouble with the criminal justice authorities. The same thing happened to the regulation system, which is part and parcel of the substantive rules. We had virtually no consistent regulation of lawyers until the late 60s. Essentially what happened was, in this country, was these local bar associations, which were referred to in the last session, essentially regulated the conduct of lawyers. And the problem was that it wasn't very effective. In fact, it was kind of scandalous. If you were a lawyer in a small town in the United States and you were the president of the bar, the fact that you might have misappropriated funds from a client, which was a total no-no, wouldn't be really dealt with because of your connections to the bar. And so in 1968, the Supreme Court of the United States and the ABA collaborated on a commission headed up by a former Supreme Court retired justice, to look at the system of regulation in the United States. And that commission came out with a report which said that the system was, and I'm using the words carefully, scandalous. That's what they said. And they recommended about 40 or 50 different changes. The most significant was removing the regulation of the bar, of the lawyers, from the bar associations and putting it into the hands of the courts. So each state adopted rules that were regulatory in nature, essentially putting the control for the regulation of the bar in the hands of the government, the third branch of government, the judiciary. And, but each state's regulatory system is different. For example, in New York, as we've referred to sort of in passing, there are actually 4 different jurisdictions to regulate lawyers in New York, 4 appellate divisions in the 4 locations, geographic locations. And the regulation is uneven among the jurisdictions. Some jurisdictions, like New York, are rather heavily regulated, or in New Jersey or Florida and California, but not so much in some of the smaller states. And it's partly a cultural thing, but it means that regulation is uneven. And how does that affect reciprocity? Well, among the other things, the rules are very protectionist. For example, lawyers in the United States, generally speaking, are not allowed to split fees with non-lawyers. And that's, by the way, true throughout the country, but it would apply, presumably, to an attempt to establish a collaborative working relationship with foreign lawyers, including lawyers who practice in India. And by the way, a lot of the law firms, the big law firms in New York, fly under the radar with respect to that. The other rules that are kind of protectionist relate to partnerships with non-lawyers and let's see the word here that I wrote down, and ownership issues, which create barriers. But there's also this whole issue about admission to practice in the United States. You know, we now have in New York a rule that allows for foreign legal consultants, which can be people who are admitted in a jurisdiction other than a U.S. jurisdiction that can come in and do legal consulting work as long as it's only consulting on the law of that country, which means if you're an Indian lawyer, you want to come to New York, you can't be a member of the New York or the U.S. bar, but you can be part of a law firm if you're only consulting on foreign legal law. But there's stringent requirements for that. But certainly to become a member of the U.S. bar in any jurisdiction is jumping through an awful lot of hoops, which is going to make it difficult for the BIA the BCI to allow American lawyers to come into India if the idea is reciprocity, because we're not there yet. And it's going to take a lot of work, patience, and flexibility to convince the American bar to be less protectionist. And that's kind of my main message, is the concern about, and there's also too many lawyers in the United States. We have over, what, a million point something lawyers. I think Japan, which is a sophisticated economic powerhouse, has something like 150,000 lawyers for a very large population. I mean, the ratio of lawyers to the population in this country is huge in terms of the numbers of lawyers, many of whom are underemployed, which is another issue. I mean, people think of New York lawyers as being very rich and wealthy and high-end, but there are an awful lot of lawyers in New York who are struggling. We know that. There are over 200,000 lawyers admitted to the bar in New York State. Think about that. There are 60 or 70,000 in Manhattan alone. Do we really need 60 or 70,000 lawyers in Manhattan? It's a very big number, and it's very significant because many of them are underemployed. So I just leave you with the thought that I think I'm very much in favor of the idea of us being closer to India, opening up the opportunity to practice law in India, but I see it as a problem that's significant from our end in terms of how we're going to accommodate that. Just to be truthful about it.
Right, but speaking in specification of the ALSP kind of a relationship, which we have been discussing, in terms of that kind of a collaboration, what are the specific ethical points which an attorney in US needs to look into while taking that decision to go ahead and start using a remote ALSP from another location?
Yeah, I think Steve's going to talk to that.
Right.
I've also thought about it. But
well, I can tell you, we're lucky to have Hal here. He has a rich history in ethics. So my history is about 24 hours old from doing a little bit of research. So I'll start off with what I learned, and then maybe Hal could follow up. So anyhow, there is a ABA opinion that was drafted in 2008. And there's about 8 other jurisdictions, Florida, I'll tell you, Los Angeles Bar Association, City of New York, San Diego, North Carolina State Bar Association, Supreme Court of Ohio, Virginia State Bar, and the District of Columbia. They've all issued opinions on outsourcing, and they all have about the same 6, 7, 8 points that they make. And I think they probably all trace back to the ABA opinion. But what you start off with is Rule 1.1 of the model rules requiring competence, okay? And we'll go back through all these in a minute. Rule 5.5, you want to make sure that whoever you're employing is not engaging in the unauthorized practice of law. And I'm going to let you define that here in a minute. Also, there's Rule 5.1 and 5.3. Both of those go to the duty of an attorney to properly and reasonably supervise their staff and their associates. And so you can't just hand something off to an outsourced paralegal and let him run with it without reviewing it, without vetting it. So you have that duty to supervise. Then there is a lot of details regarding the attorney-client privilege and confidentiality, which derive from Rule 1.6. And that goes into the duty to obtain authorization from your client to share confidential information with your outsourced paralegal. Right. That goes along with making sure you have a confidentiality provision in your agreement with your outsourced company. That goes along with making sure that everybody has appropriate cybersecurity on their, however the system is you're using to go back and forth to communicate. I know that some firms allow their paralegal, outsourced paralegal, to actually work on their system. Well, there's a Florida opinion that says, no, you should not give your outsourced paralegal access to everything in the firm. They only need access to what they're working on.
So just to be a button over here, would that mean for an outsourced paralegal who is within the United States, or
Yes,
would it
yes,
apply?
yes.
I mean, the same rules would apply.
Yes, the same rules apply in a number of these opinions, including the ABA opinion. Just expressly say, look, there's no difference, you know. And to the extent there is a difference, it goes to the amount of vetting that is required. Goes to the culture of the country where you are outsourcing, because that may implicate security issues and confidentiality issues. And so, but the underlying rules are all the same. Right. The degree to which the analysis might be slightly different is the only thing that's going to be impacted. Right. And so the great thing about India is we do share a common legal culture. I mean, it's not identical, as we know from Mr. Rosenbaum, but there is a similarity in culture, and there's a similarity in lawyer discipline for violating attorney confidences, etc. Right? Okay, and then conflicts of interest. I know that one of the things I've talked with Drafting Craft about in the past is, look, do you work directly for any of these insurance companies that might be on the other side of me? Do you work for defense firms in the personal injury field? And if you do, would that conflict with anything that I'm doing? And I know that they track that information. So it is important in the company that you're dealing with that they somehow have a system for tracking conflicts of interest, because that's going to come back on the American lawyer if that's not out there.
Right.
And then finally, fees. Depending on your practice, it will impact whether or not you could pass along some of the fees. Also, it may depend on the actual work that the outsourced paralegal is doing. For instance, I think I could ethically pass on at actual cost a medical record summary. I've never done that, but I thought about it. Because that's not something necessarily that a lawyer himself would do. You would hire a nurse or somebody like that, or a doctor to do that. But as a personal injury lawyer working on a contingency fee, I could never separately bill out the paralegal. If say we were using paralegals on my wife's side of the practice doing family law, then we could bill that out at an hourly rate. So we could end up paying X amount of dollars to Drafting Craft, and then charge X plus $75 to our client, as long as that is reasonable under the market conditions and for the experience of the paralegal. Because there's always a rule of reasonableness. But those are the general rules that you want to address, and and you're best, I think, to address a lot of these in your agreement with the outsourced company. So,
Just to add something, I found I looked at the rules on professional conduct in India that you sent me. I found significant differences in the rules and gaps in the rules, certainly with respect to American rules. And I would be interested, because as I said, I feel very supportive of the enterprise here. I would be interested in whether the ethics people in India, the BCI people who promulgated these have spoken with the ABA and the various ethics people in this country about, in way, greater integration of the rules and greater specificity of the rules so that we're on the same page. We may not be ever able to be on the same page, for example, about advertising, because it took a revolution in this country of Supreme Court First Amendment litigation to get us to the point where lawyers can advertise. But culturally, India simply doesn't allow advertising. The same thing with contingent fees, which is a major part of the economic market for lawyers in this country. India, like most countries of the world, does not allow contingent fees. So, I mean, maybe there's no way to bridge that gap, but there are other things where the gap can be bridged. For example, you spoke a moment ago, Steve, about confidentiality. But the Indian BCI rules on confidentiality really address lawyer-client communications and attorney-client privilege, but don't address, and could easily address as well, expand to address confidential communications of all kinds, whether or not directly emanating from a lawyer-client conversation.
Right.
And so that's an easy one to sort of fix or expand. So it really requires a kind of a point-by-point analysis.
And you can address some of that contractually.
Right.
With regard to confidentiality agreements,
Right.
Also indemnification provisions.
True, because at the end of the day, when we're talking about an ALSP, we need to ensure that we are following or making sure everything is ethically right at your end.
Right.
So if we are able, I mean, if an ALSP is able to address all the issues which, you know, you are highlighting over here, I think it should be a done deal, because it doesn't matter what the BCI says or what kind of rules apply to Indian lawyers, because those are not the rules which may be applicable over here. We're looking at it in a little different way over here.
Right. And when I was talking about similarity, I meant in culture.
Yeah.
Okay, the respect for the confidentiality of documents from a client, whereas maybe in some other countries, it's not quite the same. And I'm not going to mention any countries because I don't want to get kicked out of New York. But I think there are some countries where you would think twice just based on the ethos of the country. Should I have an outsourced Nigerian legal work? Right. And I'm not saying that you couldn't, but I'm saying it might require more vetting, which is one of the points that the Florida Bar has made in its opinion. And all these opinions, all of them say it's okay to use outsourced paralegals. It's only subject to abiding by all of these rules in the country that you're dealing with may impact the level of due diligence that's required. Because I can tell you, I have friends from Nigeria, and they're absolutely ethical, but like 90% of these scams you've been reading about, these young boys getting scammed and blackmailed, I read in the news the other day, they all come from Nigeria. That's evidently a fact. And so that might impact the amount of due diligence you would do if you were contracting with a company in that country.
I mean, my concern is to develop a more robust relationship. We've got a ways to go.
Right.
That's my only message, at least in this world of legal ethics and regulation. We're not really on enough of the same page yet.
Right. Anne, would you like to weigh in on this? Anything specific which you want to add when we talk about the ethics and the use of ALSP?
So the thing that I tend to focus on with all of these things is we have our rules, and we have the limits. But how do we apply those to, for example, the technological world that we're living in now? So it is very important to understand the rules that we all live under as New York or U.S. licensed lawyers, but what does that mean in terms of using and understanding, the cybersecurity protocols that we have, and how do we use those to make sure that we maintain the confidentiality and there are not inadvertent, disclosures that we are, in many cases, absolutely liable for. So I think this discussion is very important. I think we all have to be very aware of the risks that we face, not just in offshoring these kinds of services, but any time you're working with someone who's outside your firm. And then how do you manage all of that given the way we communicate now? And that includes things like using Zoom. Zoom's security is not great. I use it all the time, but I'm very clear with my clients. We have to be very careful what we say on Zoom because we can't really manage. We don't know what might be happening to the information on this. The same way I don't like talking to my clients on a cell phone. I prefer to use some kind of, encrypted, protected communications system.
Right.
WhatsApp?
WhatsApp?
Yeah, have you ever used that? That's supposed to be encrypted, isn't
I'm
it?
forced into it.
I was just curious.
I don't like using it.
In New York, the court system does not allow Zoom communications. When we were working remotely, they came up with their own system, which was based on something called Teams, which was a Microsoft product. And so you can only communicate on Teams if you're not in court in person. And I'm sure there are other apps in other states that are more secure than Zoom, but it's certainly a problem here.
Yeah, it absolutely is. I mean, there's a list of others that are much better than Zoom and Skype, which I don't think anybody uses.
Or FaceTime or whatever.
Oh, forget FaceTime, yeah.
So.
Right. So, ALSP is here to stay. We know that it has developed itself as a strong arm to a law firm. To sum up, what would be the top 5 things one needs to look into when getting into this kind of a relationship? What would you say in terms, if somebody else was looking at starting off a relationship with an ALSP, what are the top 5 things you would say, you got to look into that before you step in?
One thing we haven't really talked about is, which the first panel did talk about, but it's something I'm very conscious of once I started working across border, is to really gain an understanding, or as much as possible, of the local, of the culture in which I'm working. So it's not just the sort of general culture, but it's the business culture, it's the legal culture, and to be respectful of that. So I'm hitting on 2 of the points that you've talked about in the first panel. But I think those are very, very important because, again, this was from my experience working for the Swedish company. I always felt like the loud, pushy American, even when I was saying nothing. I just felt like that was kind of the aura that I exuded. And so I was very, very careful to understand what my colleagues were going through, how their experiences were different from mine, and to try to bring that into every or most interactions I had with them.
Steve, what would be
Well, I could tell you that I think everything comes down to due diligence, contracting, and consent.
Right.
So I think you want to be really clear what the scope of services are.
Right.
Okay, you want to talk about that going in. I know when we talked about the scope of services for my FTE, full-time equivalent employee, I said, well, medical records, but then everything else I say. So that's not as clear as it could be, but that's a nature of a small practice. I think to the extent you are a larger law firm, you are much more easily able to pinpoint the tasks that you want your remote employees to engage in. So supervision, how is your full-time equivalent employee being supervised in India? Okay, and how do you intend on supervising them in the United States? You know, you have to address that going into an arrangement. Data security. You want to speak to the company, what is your data security? You know, you want to negotiate an indemnification clause for data breaches. You may even want to ask what type of insurance do you carry, and can I be named as, and I don't know anything about Indian insurance law, but an additional insured in case of a data breach. Or you might want to speak with your own insurance company. A lot of people now have cybersecurity insurance, and make sure that if your if the remote firm in India suffers a data breach of your client's information, is that going to be covered under your policy? You want confidentiality. You want to make sure you have a confidentiality agreement and make sure that conflict of interests are addressed. Make sure you're comfortable that you're not engaged in the type of practice where the outsourcing company may be working both sides of that type of, in that field.
Right.
Okay? So like mergers and acquisitions, you know, if you're working for one large company and there's another company that's in the same industry, are you both trying to pursue the same target company? Right. You know, you want to make sure that whatever your field of practice is, that the outsourcing company is clear on maintaining an absence of a conflict of interest. Client disclosure. I think that I know for me, by contract, there's a provision that my clients will sign in the contract that basically says you understand that we will be outsourcing certain things, and you give us your consent to do that, and if you want to terminate your consent, just let us know. And then unauthorized practice of law. You know, UPL may differ based on the type of practice you have. If your outsourced employee is going to be talking to your clients, you face the same problem if your own paralegal is talking to your clients. My mother-in-law is my paralegal, and she's been a paralegal for over 40 years, 45 years maybe. And still sometimes I have to say, well, you know, don't say that to a client. Okay, it's not huge, but still. And so so it becomes more important, though, that you educate the outsourcing company to make sure they're educating their employees, your full-time equivalent paralegal, that if they are talking to your clients, there is a zero tolerance for any type of legal advice being presented from your outsourced paralegal to your clients to the extent they're talking to your clients. And then fees, if you have the type of practice where you could charge for your paralegal, just make sure it's reasonable based on the market, and probably with some type of reduction for it being outsourced. You know, but I think you would want to you would just want to make sure that what you're charging is reasonable, and you want to make sure that you never, if you're, say, doing contingency work, passing on an expense for your paralegal if they are conducting the type of work that one would expect the lawyer to be conducting. Okay, so legal research, any type of legal work your paralegal's doing should not be charged as a cost if that's supposed to be included in your overhead for what you're billing for, which is the case in a contingency fee situation.
Maybe. Maybe. It's unclear. I've had lots of examples of counseling law firms about that, and I take a conservative position like you do, but a lot of people don't necessarily see it that way, and the rules are not that clear.
And that's going to become more prevalent, I think, too, with technology. And one thing we talked about is I think the legal services industry is going to be using more and more technology, and the question is, if that technology is achieving the end that a human being was achieving, can you charge for that? You know, for instance, one thing, you know, we do have a technology company that we've done a little bit of technological programming on the family law side of things before AI, which was very painstaking Boolean analysis to the point of just being crazy. But now I'm working with with an AI software architect to create a app where you upload the interrogatories you get in a personal injury case, and they will then translate it to plain English, text each question to your client, vet it to make sure it's an answer, then translate it into proper English, and then give you some printouts to look at. That's not going to alleviate the need to talk to a client, but you'll have to review everything. But it might save you 60% of your time. But the question is that part of your overhead? Or can you pass on the cost of that?
A lot of it depends on disclosure and being clear and transparent about how you disclose that information to the client. But I wanted to say, as a more global thing, again, coming back to the relationship, one way to grow the relationship, I think, both from the standpoint of outsourcing, which exists now, and expand it, as well as the new ideas about maybe even having greater reciprocity between the countries, is to try to get more close and integrate the rules of professional conduct and sit down and try to figure out how we can make American companies and American lawyers more comfortable with outsourcing and more comfortable with using Indian lawyers and paralegals. And one of the ways to do that is to build on what Steve is talking about in terms of these areas of professional responsibility that could be more specified and more close to the American standards than they are today.
And I think you clearly want to try to build that into a contractual agreement.
Absolutely.
For sure. But it can be done institutionally as well.
Yes. Yes. But given how insular and protectionist the state of Florida has been with reciprocity, if that's any example, I'm not sure that we could expect that to happen anytime soon.
Oh, it's true all over the country. That's a big problem for us.
Yeah.
So with that, any questions which can be addressed? Anything which has been missed out, or where you think a little bit more elaboration would be needed, or we've covered it all? Okay. Looks like we were a very good panel and gave a lot of information. So.
As a lawyer, whenever I've been practicing, I could see my associate attorneys and the paralegals as my team. And when things go virtual, how do you manage that those teams are far off? So how do you take that? That's what I do. Physical to virtualization. This is a big gap which is happening.
Yeah, I mean, I can speak a little bit to that. I think you make an important point that that we've sort of addressed, all of us have addressed in a way, which is cybersecurity and also just working, getting a better product for the client when you have a team. But having worked remotely, you have these apps like Zoom or Teams in the case of New York State, and you can send an invitation to your entire team on a particular case, and then they're all on the screen discussing the case, and so you have these confidentiality concerns. But the only way to do that is with these new apps. I mean, you can't. It used to be that you would have a meeting in the office, and that's not practical sometimes, and especially if somebody's working remotely in London or in New Delhi or someplace, but it's part of the team. So you have these apps, and that's what we do, and it's a large part of law practice today. Even in New York, in a local. I'm working on a matter involving a representation of a local law firm, and we don't meet. We don't meet in person. We meet over the internet, and it's common. And we have to meet that way because it's just more convenient than getting up and walking 6 blocks away. I can't explain why. I'd rather walk 6 blocks, frankly, but that's not the way people work anymore.
I'll tell you, I mean, sometimes I think a video meeting with a concurrent use of a group document that everybody's in really is probably more productive than the type of meeting I would have around my conference room table. You know, and part of it is everybody working on the same document, recording strategies, recording things that need to get done, recording arguments that need to be made, because sometimes when you're having a team meeting in a litigation case, and you are literally brainstorming, it's great to have your associate there getting everything down in real time for you to look, for you to tweak. And so, and then the flip side is, how do you deal with employees who are working remotely, for which you have no direct knowledge of what they're doing unless you're on a call with them, and that is more challenging. That, I think, goes to the hiring process and making sure that you're hiring people that are self-starters, or you're giving them so much work they don't have time to goof off. So, and I try to do both. Though I did have a situation with my, that I had gotten to where I believed that maybe he was only working about 15 hours a week.
Okay.
And I was paying him for 40. I don't know. I really don't know. But when it worked for me, he did 10 times or 20 times the amount of work in 1 month than the person he replaced. So, made me think.
I'd like to say something controversial to leave everyone thinking about. Don't eliminate in-person meetings completely. There is nothing like seeing people face-to-face, whether it's once a year, every 6 months, over a meal, over an extended period of time. That was how I was able to work with my colleagues in Sweden so effectively without seeing them for 4.5 years. Was we spent 1.5 years meeting every 8 weeks. And we were able to develop those relationships, develop the trust, develop the communication skills, because we'd spent time in each other's presence. So I think you can get away with eliminating most of it, but you really do need to meet in person periodically.
Can I say one thing before we close?
Yeah, absolutely.
I just want to thank y'all for having me come here. It really has been a privilege to speak at the Consul General for India. I told my mom that, and she was like, "Oh." So I neglected to mention what an honor it is, but I do. I think it's really cool to be here.
I would like to invite Mr. Sharma for the Momento presentation. Danish. Can we have Ann Wolfson, Chairman, New York City Bar Association?
Great, thank you very much.
My pleasure. Thank you for inviting me. This is wonderful.
I really appreciate the way you said the physical meetings are really important. This is, as a lawyer, I also feel that
Yeah.
you don't have the people around you.
Can we have Hal Lieberman, partner, Emery, Celli? Steve Kong, partner, Commons and Greene. Anjali Pahwa, Senior Vice President, Draft and Craft. Thank you all the panelists. Thank you, Anjali. Thank you, sir.